Okay, good afternoon. Can everybody hear me? Just type in the text box, the chat box at the bottom, if you can hear me. Yep. Thank you, Kieran. Thank you, John. Thank you, Laura. Okay. Okay, I'm just going to give a couple more minutes for a few others to arrive. We normally get a few latecomers. I think this presentation normally takes 45 minutes to 1 hour. Really depends on how many questions we have and how long it takes to answer them. If you do have any questions, just type them in the chat box at the bottom of the page. I'll be able to see them here. It's got a moderated chat, this software, so and I'll answer them as we go along. If for any reason I don't answer it, it's probably because too many questions are coming in and I can't deal with them all. But what I will do is I will download a transcript of the entire chat and I'll email you directly with the answers to that question after the event. Okay, just a couple a minute or two longer. Okay. I'm just waiting for a few more people to arrive, so I turned my audio off so you wouldn't hear my clunking in the background. Okay, let's get started. We've got a pretty good attendance here today. Let's just 2 seconds while I just turn all my notifications off so we don't disturb this. Okay, so trust in estate planning for expatriates in the Philippines. This is the third one of these we've done. We did 2 last week, and if I don't say so myself, I don't want to say so myself. The feedback we've had has been absolutely fantastic. And I've had meetings and phone calls with people subsequent to this webinar, and yeah, I mean, people are really benefiting from it, and they're finding the information invaluable. So it's great, and thank you all for attending. So, as you can tell by my accent, I'm not Filipino. I am living in Manila. I have no Filipino roots whatsoever. What really gives me the sort of permission to talk with a bit of authority on this is I believe my claim to fame is I'm the first and only foreigner in this country to have completed the Chartered Trust and Estate Planner program, which I did earlier this year. It's endorsed by the American Academy of Financial Management, and it's a 6-week program, so not that long, but it really gives an invaluable insight into the way in which the trust and estate planning and succession laws work in this country. Yeah, it's a really worthwhile qualification to have. So why are we doing this seminar? Everyone I speak to about this, really have no idea about the estate and succession rules in the Philippines. They really have some quite quirky rules that, being from the West, we may not be familiar with. And having had meetings with people since the face-to-face seminar we did a few weeks ago and the webinars last week, one guy said to me yesterday, he's never learned so much about estate planning in the last week as he's done in the last 16 years. So it's really valuable information we're sharing here, and I think everyone will get a lot out of it. The idea is that with some simple and straightforward planning, you can make sure that your estate is left to who you want it to go to, or as much as possible of that, because the government dictate a lot of what happens when you die, and what happens to your money. So what we're going to cover is what actually happens when you die in the Philippines from a financial perspective, and how the BIR react to that, and what they do with your assets. We'll cover the forced heirship, or legitime as they call it here, which details things like compulsory heirs, and how your estate should be distributed. Wills and trusts. There are different types of wills you can use here, as well as trusts. They have estate tax here, so like inheritance tax in the UK, and also donors tax if you want to gift assets before you die. And finally, how we can start to get things in order, so you can get your estate in a good setup, so that you can be confident that it's structured in the right way, so your heirs are looked after when you pass away. So what happens when you die in the Philippines? If you die without a will, or intestate, or no form of estate planning in place, that's like a trust or anything like that, your assets are basically distributed according to the intestate succession legislation. So that would basically, they tend to favour legitimate children and spouses, but typically the government would if you have no heirs, then your condo or your cash in the bank, or whatever, will end up in the hands of the local municipality. So that will be the local, could be the local barangay hall, or the local city hall, or whatever. So I'm assuming most people don't want that to happen. So it's a worthwhile exercise to do something about that before it's too late. If you have a will, it must follow the forced heirship legislation. We'll come on to that later. And that basically ensures that your compulsory heirs are looked after. You have to pay the estate duty within 6 months from the date of death. If you're lucky, the BIR will give you a 30-day extension if you can't pay it within that time. But and if you don't pay it on time, there's a 25% penalty for not paying it on time. The last two are probably the scariest. If you have a bank account in the Philippines, the secrecy laws are completely lifted, and the BIR can go into your bank account and look at the transactions for pretty much as long as they want to, for as long as you've held the account, pretty much. I mean, some people say it's 5 years, but reality is, that if they want to find it, they'll find it. And that's really to basically ensure that if there are large amounts of money that are disappearing from your bank account in the form of gifts, they're going to make sure that's brought back into your estate, to ensure that either the donor's tax has been paid on it, or the estate tax is paid on it. And lastly, and I think this is the scariest, is that your bank accounts are immediately frozen. And trust me, the BIR, you don't need to tell them about this. They will find out on their own. They will monitor obituary columns and death records. I believe even hospitals are obliged to inform them. And as foreigners, if you die in the Philippines, the hospital have to inform your local embassy. So there is some external reporting there. And once that happens, no amount of pleading with the bank manager, no amount of begging, whatever, they will not allow you access to that bank account until a tax clearance certificate has been issued by the BIR to ensure that the estate tax has been paid. Okay, so what that can mean is that if you have family here that are reliant on the cash in your bank, or if you're the main breadwinner and most of the money sits in your bank account, your family will not be able to access that money with no questions about it. It's frozen. It's stuck. And that money can't even be used to pay the estate tax. The estate tax has to be paid before the bank accounts are unfrozen. Okay, so, I think that's the scariest one. And I so many times I've seen people, both local Filipinos and expatriates, who have been victims of this. And again, what we're going to cover today is how we can plan for this to make sure that you maintain liquidity after your death for your family. Okay. So next slide. This is an advert here for a Patek Philippe watch, and this advert really sums up the succession laws in this country. And you'll see what I mean at the bottom, where it says you never actually own a Patek Philippe, you merely look after it for the next generation. And that is exactly how it works in this country with your assets you hold here. Whilst they may be in your name, or you join names with your wife or anyone, it's government dictate or the law dictates how those assets are distributed after you die. So just like the Patek Philippe watch, you're just looking after it for the next generation, and the government have already decided who those assets will be left to. So yeah, that's. I thought that was quite a nice analogy to draw that with the succession laws of this country. So that brings us on to forced heirship or legitime. Basically, this is designed to ensure that the direct descendants or ascendants, in some cases, if your parents are still alive, receive their fair share of succession throughout the generations. It's basically there to ensure that if you've amassed an amount of money, that you don't leave it to the local donkey sanctuary or a mistress or anything like that. It's designed to ensure that your immediate heirs are looked after, and that's typically legitimate children and your spouse. And Article 886 of the Civil Code defines legitime as that part of the testator's property which he cannot dispose of because the law has reserved it for certain heirs who are therefore called compulsory heirs. And we'll come on to compulsory heirs on the next slide. But you can see here that this legislation is in the Civil Code. It's law. There's no if, buts, or maybes. This is how succession works in the Philippines. And lastly, Article 1061. Every compulsory heir who succeeds with other compulsory heirs must bring into the mass of the estate any property or right which he may have received from the descendant during the lifetime of the latter by way of donation or any other gratuitous title in order that it may be computed in the determination of the legitime of each heir and in the account of the partition. What that basically means is that anything you've given away during your lifetime, whether it be to your compulsory heirs or to anyone else, has to be brought back into the estate to ensure, one, that the donor's tax or the estate tax has been paid on it, and two, that you've given it away to the right person. To give an example of that, if you were to give a property away to a friend who has no relation to you at all, and that friend will be classed, from this perspective, would be classed as a stranger, then your compulsory heirs have every right to claim that property back, or the value of that property back from your estate. And in some cases, they can go after the person you've given it to. And a gift can be defined by way of giving away something for free, or if you sell a property for less than fair market or zonal value, whichever is higher, then the difference between the fair market value and the sale price is counted as the gift. Okay, so it's worth noting that as well. Okay, if you've got any questions, as I said, just feel free to type them in the chat box. I haven't had any yet, so I'm sure we'll get some as we go along. Graham's just asked, do joint bank accounts get frozen? Yes, they do. If you have a joint bank account with your spouse or anyone for that matter, if you die, then your joint bank account is frozen as well. So whatever you do, don't have have a joint bank account, but also have one in separate names as well, with individual cash balances in it to ensure that both of you can access money if the other one were to pass away. Okay, so compulsory heirs. So legitimate children are first in line. They will typically receive 50% of the estate, and which is shared equally between all legitimate children. And legitimate children are defined as children who are born in wedlock or legally adopted. Illegitimate children, which are obviously born outside of wedlock, are entitled to half the entitlement of one legitimate child. Your spouse is then entitled, well, it varies from situation to situation, but typically your spouse will receive the same share as one legitimate child, and I'll give an example of that in a moment. Parents, if they're still alive, can also be a compulsory heir, not always. Sorry, I've just someone said the audio's gone good. Can everyone hear me okay? Yeah. Okay, I think probably just the internet. Oh, bad sound. Okay, sorry. The audio. Is it okay now, Kieran? Laura, can you hear me? Okay. Okay, I think we're okay now. And then finally, siblings, aunts, uncles, and cousins. Whilst they're not necessarily compulsory heirs, in the absence of other heirs, then they can be compulsory heirs, but they're last in line to inherit from your estate. Okay, and then lastly, the free portion. That's basically what's left after your compulsory heirs have been accounted for. Then what's left is the part that you could give away to your friend or your donkey sanctuary or dog's home or charity or whoever you want. And that, as I said, that can be used for anyone, and that's particularly useful for in the case of common law or same-sex partners, because a common law relationship or a same-sex relationship isn't recognised in this country, and they're not considered a spouse. So going back to the forced heirship, your spouse, if you're not married but have a long-term living partner, he or she would not be recognised as a spouse in this instance. However, there is no free portion if you die intestate, i.e., without a will. So it's quite important to ensure there is a will in place, particularly if you have no heirs, to avoid it ending up in the hands of the local government. So let's give you an example. So that's typical family, spouse and 2 legitimate children. So in your will, under testate succession, you would have to provide 25% for each child, so that's 50% in total, which is what their children split 50% of the estate between them. And then the spouse would receive the same share as one legitimate child, which in this case would be 25%. And then the 25% is you can leave to whoever you like. If you die without a will, then your estate is divided equally between your heirs, so 33.33% per person. It just on the spouse. It's worth noting that in the Philippines, when you get married, whether the assets are 100% in your name or joint names, or a different share thereof, a marriage, the moment you say the words "I do," your assets become 50% owned by your spouse. Whether, as I said, whether they're owned by you in name or not, and this is known as conjugal property. So, whilst in this case you would only leave 25% for your spouse, if you have a property here, like say the family home, your spouse would already own half of that anyway. So what we're talking about is your half of the estate here. So and your spouse would own the other half, as I said, regardless of whether it's in joint names or not. Okay. This is where it can vary slightly. A spouse and one legitimate child. If you have a will, obviously the child's entitled to 50% of the estate. However, in this case, the spouse. This is the only case where the spouse gets a different share from the legitimate child, because he or she is only entitled to 25%. And then again, you've got the free portion again. And if you were to die intestate, then your estate is divided equally between your heirs. Okay. In the case of a spouse and an illegitimate child, in your will, you are allowed to leave 33% to your illegitimate child and 33% for the spouse, and then the free portion. Or without a will, then it's 50-50. There's so many different examples of this, but I can. John just asked a question. Does the spouse own 50% of bank accounts savings? Yes. Basically, the moment you get married, then your assets are equally owned equally. And as I said, whether they are in your name or not, or in joint names, that's just the law here. They call it conjugal property, and the only exception to that rule is if you were to inherit property whilst you were married. So if you inherit property from, say, a parent or relative before you get married, that forms part of your conjugal property. But if it's after you get married, then that property would form what's called exclusive property and would be solely owned by you. And that's quite important here for those of you that have children that are over the age of 18 who are considering getting married. In that, if you want to ensure that that property is owned exclusively by them, it's best to put a clause in your will to ensure that your property is bequeathed to them on or after marriage, to ensure that they get the sole benefit of that property rather than doing it beforehand. Okay. So in the case of legitimate children alone, then 50%, legitimate children are always entitled to 50% of the estate, and then 50% of the free portion. So I was just saying that there's a lot of examples of these, but when I click the end event at the end of this seminar, it will take you to our webpage, which has what we call an estate planning questionnaire. And if you are happy to share just a few very generic details about your marital status and how many children you have, or any other family members you have, then we will then drop you an email back with what your forced heirship or what your ledger team will be, and you can use that email to plan your will accordingly. What else? I'll give one more example. And then illegitimate children only. Then it's just 50% of the estate divided by equally between all the children. So it's the same as a legitimate child in this. Okay. And then in interstate, they would receive 100%. Okay. So grounds for disinheritance. So say you have a compulsory heir that you don't like, and you want to ensure that they don't receive a benefit from your estate. Then the Article 919 lists a few reasons how you can disinherit them, and it's worth noting that if you do disinherit them, it's still subject to the probate court. Yes, I will deal with that later. Kieran's just asked, you may deal with later, but as a quick question of assets, worldwide or local, we'll come on to that in a moment. So you can disinherit someone if someone has made an attempt against your life or your spouse or descendants or descendants. The key word here is attempt, because if that individual is successful in their attempt to kill that individual, then they can't be disinherited. They have to fail at attempting, which seems a bit silly in my opinion, but apparently that was ruled in a court several decades ago. If they've been in prison for a crime, adultery, fraud, coercion, not supporting your parents, so if your children don't support you enough, then you have every right to disinherit them. Mistreatment, the last few are a bit subjective. Mistreatment or lead a dishonorable or disgraceful life. So if your heirs are involved in drugs or gambling or anything like that. But again, this is all subject to the probate court granting this disinheritance. So and this is what can grant the probate process up, which we'll cover probate in a few more slides. And if someone contests a disinheritance, then you can then that can really delay things if they take the court or the probate court. Okay, so that brings us on to wills. The three wills are acceptable here. There's a notarial will, which is what one you would do with a lawyer. The holographic will, which I'll come on to that in a moment, because that's quite unique. And then wills written overseas. Okay, so the notarial will, it must be prepared by a lawyer, obviously. You have to have 3 witnesses, and the signing and witnessing should be videotaped. And literally, I mean, they kind of say you should sit there in the lawyer's boardroom with the lawyer there, the witnesses there, a copy of that day's newspaper on the front to show the same date of the newspaper is the date on the will, and then everyone has to be recorded signing it, basically to stop people saying that that person never wrote that will. And quite honestly, any contract of significance in the Philippines, this is a very worthwhile exercise, because you hear stories of people signing contracts and then those signing them never honour them, and they say they've never been signed. Okay, so as a result, a lot of people involved. It takes quite a bit of time. It's costly, and as you'll see in the next slide, it's not really necessary, because what you can do is what's called a holographic will. And according to the Civil Code, a holographic will is one entirely written, dated, and signed by the hand of the testator, meaning it has to be written in your own handwriting. It cannot be typed out. Okay, it has to be dated, obviously, signed by yourself. And lastly, which is a bit odd, it must not be witnessed. And I'm not quite sure why. I suspect if it's witnessed, then it would fall in the parameters of a notarial will. but the holographic will is an extremely widely used form of will in this country. Most attorneys will use a holographic will here rather than doing one a notarial will. And the best part of it is it's absolutely free. It doesn't cost you a cent or a centavos. So you can write one of these out, and I've got an example of one here, and this one is typed, but we just use this as a template, and it basically just states who you are, how you want your estate to be distributed, as long as it follows the ledger team, details the executors, and then the date, and then your signature, and that is it. And if you fill out the estate planning questionnaire at the end of this seminar, we will email you this template, so you can then write your own will. And as I said, there's no cost for that. You don't need to get lawyers involved. And even it's been a photocopy of the holographic will be accepted here. Some people say it's a good idea to have a photograph after you've signed it. Have a photograph with yourself and the will in your hand to show it's you're holding it and you're aware of it. Or some people say you need to put it in an envelope and courier it to yourself, and then keep a copy of the signed delivery slip. Just basically to show that it's you that's done it, and it makes it harder to contest if your heirs ever try to contest your will. Okay, and then last one, overseas wills. I mean, yeah, they generally will be respected. However, the problem is if it doesn't follow the ledger team, then it's a pretty useless document, and they can't, because they're not. It's not a legal document in the Philippines necessarily. It can be easily disputed, and also you also run the risk of disclosing assets outside of the country as well, which you may or may not want to. So, quite frankly, having a local holographic will, it takes probably about half an hour to an hour to sit down one morning and write it yourself. It doesn't cost anything, and it just eradicates all risk from your estate planning to make sure your assets are given to who you want them to go to. Okay, so moving on to probate. So basically, probate is basically the probate court is who grants probate, and your will. And if you've done a holographic will, this will would be sent to the probate court and to instruct them on how to dispose of your estate. Probate, here it can take anywhere between 3 months and 2 years, sometimes longer. It's usually a fairly straightforward process, but it does take time. And it's worth noting that you can't sell your estate cannot sell any assets or any properties or anything until probate's been granted, because your heirs won't own the assets. So, and also if someone contests the will, then that just stops the probate process in its tracks, and that's when it starts to get very take a lot of time to finalise. They don't do it for free, so they'll take the cost of the probate courts from your estate. You have no control over what they decide. So if you have disinherited someone in your will, and then they contest it and decide that they should be they shouldn't have been disinherited, then they will ensure that your will is amended to ensure that your compulsory heirs are looked after. And of course, and you may not know this, a will is, after you die, a will becomes a public document, and that's quite common throughout the world. I mean, if you go online and search for Michael Jackson's will, it's there and you can read it, and I think it's only about 2 or 3 pages long, but it becomes a public document. So if you may not necessarily want people to know about what you've left to who, or what assets you've got, and it's just worthwhile noting. The next form of succession planning are trusts, and I mean there are literally so many different types of trusts in the Philippines and around the world. So I'm not going to cover them all. I'm just going to cover the 2 most basic ones here. But the most powerful part of a trust is that it can do what a will can do, but more. And that part more is quite key. It basically avoids probate, because once you put your assets in a trust, the trust never dies. You may die, but the trust doesn't die. So you can place your assets in there. As long as you follow the forced heirship legislation, you can die, and your trust can dispose of that property or do with it as you instruct as part of the trust deed. And it's a very clean way of doing things, but it's not the simplest way to set one up. The two types of trust that we're going to talk about today are revocable and irrevocable. So a revocable trust is set up during your lifetime. You can cancel it at any time or revoke it, hence the name revocable. Whilst you put the assets in a trust, it still remains part of your estate, purely due to the fact that you can revoke it and therefore subject to estate tax. You can retitle property into the trust, and I believe they do charge the property transfer tax of 0.5% if you do that. But you retain full control of those assets, but the trust will still avoid the probate process. So it's a very good way to avoid probate. It's not too expensive. You won't be hit with any donors tax or anything like that. And it just makes it's a very clean way of leaving assets or your estate to your heirs. Okay, moving on to irrevocable trusts. So once this is set up, you can never cancel it, and you can never have your money back. It's basically a gift into a trust from which you can no longer be a beneficiary. So as a result of that, it's subject to donors tax. And donors tax is something we'll come on to later, but in essence, I mean, it's basically to stop people giving all their assets away. So instead of charging estate tax, they charge donors tax on it instead. But as a result of that, it's excluded from your estate on death. So it's not subject to estate tax. So there's a small tax saving there. Most banks here will do irrevocable bank trusts, and this is quite a useful tool, because the limit or the tax-free limit on donors tax is 100,000 pesos a year. And whilst that may not sound like a huge amount of money, over a period of 10 or 20 years, that can generate 1, 2, or million pesos, if not more, with investment growth. And what that can do, because it doesn't form part of your estate on death, it basically allows you to create this liquidity for when you die, so that when your bank account is frozen, when your property can't be sold, what you have got available for your family or your heirs is the irrevocable bank trust, which they can access immediately on production of a death certificate and a will, and the trust deed as well. And also it's totally private, because the trust doesn't die. Then the trust is completely private. So what you can basically do is deposit, as I said, 100,000 a year into a irrevocable bank trust. You can invest it however you like, and it will provide some very valuable liquidity to your family when you pass away. Okay. Okay, and Kieran, this comes back to your question. So what's included in your gross estate? So if you're a resident alien here or a citizen, so basically if you have a retirement visa, work 9G or 13A or 13G, anything like that, then you are taxable on your worldwide assets. Whereas if you're non-resident, it's only on assets located in the Philippines. So it's just worth noting that if say you're from the UK and you're subject to inheritance tax, the BIR will grant you a tax bit on any assets taxed on overseas. But yeah, it's kind of worth noting that they will only be able to tax them tax your estate on those assets if they find out about them. So yeah, read between the lines there, you'll know what I mean. So what is included in your gross estate? There's a whole list of things here. The two main ones are life insurance, and life insurance here is only excluded from your estate if you've irrevocably appointed a beneficiary to that life insurance. So if there is no beneficiary on that, then it's formed your estate. But if you say have set up a life insurance and you've appointed your spouse or your child as the sole beneficiary and irrevocably appointed that person, then it falls outside of your estate. And that has a number of benefits. The first one, again, you can use that life insurance to pay the estate tax. And then secondly, that again, it's all about providing liquidity here. So that life insurance payout can be used to finance your family after you've passed away. Okay. And then the other big one is the property of your spouse. So going back to what I was saying about conjugal property, and just to remind everyone that was the section where the moment you get married, all of your assets become jointly owned, whether they're in joint names or not. So say your estate was, say, 50 million peso, and it was all conjugal property. 25 million of that would be removed from your estate because basically your spouse owns it. So your net estate would be, after deductions, or before deductions, 25 million. Okay. So what are the deductions? So any expenses, losses, indebtedness, and taxes. So that would cover things like probate court, or any expenses incurred as part of the execution of the will. Property previously taxed. This comes back to what I was saying about exclusive property. So if you inherited property, or your spouse has inherited property in the last 5 years, then they give you a tax credit for that, if tax has already been paid. So if it's been inherited in the last year, or any time between now and the last 12 months, then you get 100% tax relief. Then within 2 years, it's 80%, 3 years, 60%, 4 years, 40%, 5 years, 20%, and over 5 years, there's no tax relief at all. Okay. Transfers for public use. That is anything given to the government. Believe it or not, some people do. The family home, they give you a whopping £1 million peso deduction for the value of your house. Another £1 million, which is just almost like the standard deduction. So it's a bit like the nil rate band in the UK. You're allowed to claim for medical expenses up to £500,000, and funeral expenses up to 200,000. But those last two have to be supported with receipts and documentation to ensure that they are actually legitimate expenses. These amounts sound very small, and the reason why is because they haven't changed in I think 20 or 30 years. There's no indexing of these deductions. Back in the day when £1 million peso was a huge amount of money, it hasn't changed since then. Okay, so and then if you're a non-resident, the only deduction you don't get the resident deductions, which is things like medical expenses, funeral expenses, standard deduction, and family home deduction. So it's basically anything other than those, if you're a non-resident here. Okay, so this is the estate tax table. So basically, if you, again, as I said, these tables were created 20 or 30 years ago. But if your estate is under 200,000 peso, then there's no tax to pay. I'm assuming everyone in this webinar today has more than 200,000 pesos in assets. But the one most people would fall into in the expat world is the last one. So anything with 10 million or above, it's a flat tax of 1.215 million plus 20% of anything over 10 million. So if your net estate was 20 million, it would be 1.2 plus 20% of 10. So 3.2 million pesos in estate tax. Okay. And on the next slide, I'll warn you before I switch over to it. It looks a bit of a mangle of figures, but it's basically this is an estate tax calculation of I just took this out of a book. But what you can see here, if I get my pointer here to highlight it. So this guy he inherited some property during his marriage, so that's exclusive property, and then everything else is conjugal. So his total estate is 13 million. Then we take the deductions off, so that he's had some claims against his estate here. His funeral expenses are 200. Real estate taxes, so things like property transfers, that type of thing, you can claim that. Judicial expenses, that would fall under the probate court. So he can deduct 1.2 million. So his estate after deductions is just under 12. Moving on, the share of the surviving spouse. So you would take half of the share of the surviving spouse, which is this number here. Go back to the previous slide. So your biggest deduction is your wife's or husband's or spouse's share, and then you take off the standard deductions, family homes, and other deductions. So your net taxable estate is just under 3 million in this instance. So and the reason for showing you this is that whilst the taxes seem quite high, the deductions really do take it down quite significantly. Because if you look back to the previous slide, initially his estate was worth 13 million, and now the tax is only due on just under 3 of it. So if we go back to the table, so his estate is worth just under 3. So if we go back to the table, he would fall into this bracket here, so between 2 and 5, and that would be his tax bill. So his tax here would be 239,000. I appreciate this may not be the same for the expatriate population here, but I just put this in just to show you. It's really to illustrate the effect of the speculative deduction and also the standard deduction and how it's calculated. Okay. Oops. So, how can we plan for estate tax? The short answer is that it's very difficult to. I believe there's a clause in the tax code that basically says any measures taken to avoid estate tax will be deemed illegal. So anything you've done to try and avoid it means that you won't get away with it. The best option you have is to create liquidity. Using, I've listed some methods here, this, as I mentioned, you've heard me mention that word liquidity quite a few times now. This is the foundation of Illinois. It's not about trying to avoid taxes here. You can't. It's about ensuring your heirs and your family have money in the bank that's accessible when you die to ensure that they can survive and pay those estate tax and get the share of the property that they're legally entitled to. Okay, so one you can do is it's called PERA. This is a new product offered by the banks here. That stands for Personal Equity and Retirement Account. It's a bit like a pension, and that has been ruled by the BIR that any contributions, any growth, or the value of that is exempt from estate tax. Life insurance, anything with an irrevocably nominated beneficiary, then that's exempt. The irrevocable bank trust that we discussed earlier. Up to 100,000. That's a very worthwhile exercise. And I put here undated checks or an ATM card. I mean, you could leave signed undated checks in your safe at home, and your family could cash those as and when required. But the problem is, a check takes 3 days to clear here. So if between that check being banked and the check clearing, if the BIR frees your bank account, then they're pretty stuffed. So it's a good backup plan, but it's not 100% foolproof. So you have to ensure that you've got other means of creating liquidity. And the ATM card is an ATM card where you put it in your safe and let someone know the PIN number, and they can draw cash that way. But again, you can only draw 50,000 a day from an ATM here, so it's not the most foolproof way of doing things. But the key is, estate planning, as I said, is not about avoiding tax. It's about creating liquidity to ensure that the taxes can be paid, and two, that your family have enough money to survive. Okay. Right. Donors tax. So again, donors tax is designed to stop you. Well, not to stop you, but to stop people thinking they can give their assets away to avoid estate taxes. So a donors tax is a tax on a donation or gift. Should be paid within 30 days. Transfers to the government are exempt, of course. Spouses should file separate returns in case you're gifting from one spouse to another. And a gift to a stranger is taxed at a flat rate of 30%. So going back to what I said at the very beginning of this talk, just because you can gift your assets doesn't mean you can ignore the forced heirship legislation. So if you gift your assets to someone who wouldn't, who isn't a compulsory heir, then there is a tax of 30%. Brian has asked, what if the life insurance beneficiary is revocable? That's only relevant. This is only relevant to Philippine insurance. But if it's revocable, then it forms part of your estate and is subject to estate tax. In short, again, I'll come on to this later. But one solution to that, Brian, is to do an overseas insurance policy. And there's nothing illegal about doing that. As I said, worldwide, if you're a resident here, worldwide assets have to be declared. But it's out of the reach of the BIR, meaning that you can still declare it, but they won't be able to freeze it. So you could set up a life insurance overseas or offshore, as we prefer to call it, and nominate whatever beneficiary you like. and then if you need to change that, then you can change it at a later date. Okay, so back to donors tax. So this is the donors tax table. So you can see here it's slightly lower than the estate tax. Instead of 20%, it's 50%. But not many people. Kieran, yes, a common law, the partner is deemed to be a stranger. As I said before, a spouse, you have to be legally married. A common law partners are not defined as a spouse, and they are not a compulsory heir either. So so when it comes to writing your will, you would have to provide for them from out of your free portion. And it's very common. This is the case. In myself personally, but I'm not married, but I have a common law partner, and we have a son. But there is no provision in the law for a common law partner to be a compulsory heir. Okay, so yes, they're a stranger basically. Okay, so we're 4 slides away from the end, so I reckon we'll be done before the hour, unless we've got any more questions. So land ownership. I'm sure there's people here today that own land. Foreigners can't own land, but the only way you can own land is by way of intestate succession, and that's covered in the Constitution. That if your spouse leaves land in your will, and as a compulsory heir, you're entitled to 50% of it. If she doesn't have a will, then you can inherit that land. If she does have a will, you cannot. Okay. So, however, that's only relevant, and again, this is quite rare, if there's no surviving family of your spouse. So, I've assumed that the spouse is a female here, but if your spouse were to pass away with her parents or siblings living, then you would, or not living rather, then the widower would be entitled to the wife's entire estate, including the land. That's only if there's no will being written. However, if the parents or siblings are still alive, then you would end up potentially owning that part of that land with the wife's family, and the problem that causes is often the family wants to sell the land and have the money, and if your family home is built on top of that land, that can cause some problems. And whilst you can dispute it, it's not a nice process to go through. It can go on for years, and of course there's lawyers to pay. What is a good idea if you haven't done this already? Most people have done this, but if you have if your partner owns the land, so typically the setup is that the wife owns the land, and then the property itself is in joint names on the title. The best thing to do is to do a 50-year lease agreement between yourself and your wife to ensure that you can remain. Whilst you may not own the land, you can remain on the property for the next 50 years, and you can even put a renewal clause on that as well. So that way, whilst family, the other family may inherit that land, you have a legally binding contract that enables you to stay in that property. Okay, and any lawyer can do that for you. And we have a panel of lawyers that we can recommend if you need that. Okay. What can you do immediately to be getting your estate in order? So, the first one, and this is absolutely the most important one, and there is no excuse for anyone here not to do this. Is to write a holographic will and your spouse, to cover the conjugal property. If you fill in the estate planning questionnaire, and when this seminar is ended, we'll send you the template for that, and you can sit down and write it out. It can be done in half an hour or an hour. And it's done, and you never have to worry about it again unless your circumstances change drastically. Okay, write a living will. We've not covered that yet, but basically that's like an enduring power of attorney, where if you lose the ability to manage your assets whilst say you're in a coma or have dementia or whatever, that enables you to appoint someone who can manage your affairs whilst you're incapacitated. You can consider the use of offshore bank accounts or trusts. If you have an offshore bank account, again, that can't be frozen when you die. And again, your spouse can have an offshore bank account as well, and money can be accessed from that. And again, it's all about creating that liquidity. Life insurance, again, if it's irrevocably appointed here in the Philippines, then you can do that. Again, you can do that offshore as well, and that gives you a little bit more flexibility. Again, it's worthwhile considering. You need a lawyer to do that for you, or an attorney. But this would the most commonly one used is the revocable one, because you're planning for probate. Irrevocable is more used of the bank trust. But if you're happy to give your assets away, then it's irrevocable is fine. Okay. Again, the undated checks and separate bank account with sufficient funds and give you part of the ATM card and PIN. Again, that's all about creating liquidity. A donation of 100,000 a year to either an individual or an irrevocable trust. Again, it's probably the latter is a better solution, and you can create amass quite a significant sum over a period of say 10 or 20 years. Again, and it will provide that liquidity. Pair the personal equity and retirement account for yourself and your spouse. You can set one of those up, and again, it will, a bit like the irrevocable trust, that will create that level of liquidity. If you own your own company here, you should ensure there's death provisions in your shareholders agreement to make sure that either your partners can buy your spouse out of the business if she inherits those shares, or your spouse can buy out your partners, whichever way you want it to. Lease agreements on land. As I said, if you inherit land by way of intestate succession, or if you can't inherit by way of intestate succession, then if you have a lease agreement on the land itself, then whilst you can't necessarily inherit the land, you can still live in your house, and you won't be homeless. So and this last point here sums it up. It's all about providing liquidity for your loved ones and your family. As I said, estate taxes. There's not really any way you can get out of it. There's no planning methods, no wacky trusts or any form of tax avoidance schemes or anything like that. If the BIR know about the assets, then they'll tax you on them. But what's down to you is to make sure that there's enough liquidity to be able to pay that tax, and two, to be able to ensure that your family have enough money to survive. So, final slide. How can we help? Wouldn't be a seminar with a little bit of a sales pitch at the end of it. So we have a panel of lawyers here. What lawyers I've used companies as well as I've used personally, who charge reasonable fees and are reliable. We can help you through the holographic will process. So if you want to have a phone call or a meeting with us, then we can sit down with you and just talk you through in a bit more detail about your forced heirship, and who can and can't be included in your will. We can set up an offshore bank account in somewhere like the Isle of Man if that's something of interest. If your only bank account in the world is in the Philippines, you really need to give serious consideration to setting up a bank account overseas. And again, offshore trusts and wrappers. If you have assets that you want to protect outside of the country and from things like bankruptcy or divorce or anything like that, there are trusts and wrappers we can use that are, say, Isle of Man based. And those can protect your assets from that. And then finally, we can do international life insurance as well. So, and life insurance is, it doesn't have to be that expensive. And even if you're in bad health, if you're under 65, we can get you up to $500,000 worth of cover without any medical declarations. So it's a worthwhile consideration. So if that's something you're interested, please feel free to contact us. I will type my email address in the chat box here, so you will have it, globalmarine.com. Do you have any thoughts on prenuptial agreements? I don't think they exist here, Kieran, because the whole marriage thing here is taken quite seriously, and prenups don't really go against the grain of what the civil code is dictating in terms of how your estate is dealt with. So conjugal property is conjugal property. I've not come across a prenup here, so so I can't really comment, and I don't think they're allowed. Okay, so my email address is on the bottom there. Feel free to drop me an email. You might have noticed when the invites came out from this click meeting software, that it came from a personal Gmail account. That was purely because our spam filter stopped the registration email coming to our Global Eye account, so I used that. So feel free to reply to that as well. But I'm very much employed by Global Eye. I'm not a kind of a lone wolf doing this on my own. So feel free to reply to either that email address or my Global Eye email address that I've just put in the chat box there. And if there's no more questions, it doesn't look like there are, I'm going to press the end event button. So we've done it in just under 55 minutes, which is good. And the end event, once I've ended this event, it will take you to the estate planning questionnaire. Feel free to fill that out, and that will automatically be sent to us. And we'll drop you an email with your forced heirship or legatine percentages, and also a template of the holographic will. So doesn't look like there are any more questions. So thanks everyone for listening, and feel free to get in touch if you have any more questions. Thanks very much, and have a good national holiday.